In our previous two lectures, already we have discussed regarding climate change, global warming, and biodiversity. And in this lecture, we would like to discuss about sustainable development. So, what exactly sustainable development means? It means, in literal term, the process or the way in which the economic planning should be given shape so as not to disturb the ecology. Due to its importance, the international community takes the view that there is the need to treat environment and development in an integrated manner. Accordingly, sustainable development has four objectives. So, the first one is a commitment to preserve natural resources for the benefit of the present and future generations. And the second objective is the use of appropriate standards for the exploitation of natural resources in prudent, rational, or wise manner. And the third objective is that equitable use of natural resources. And the fourth objective is environmental issues must be integrated into the economic plans, programs, and projects. The principle of sustainable development was first expounded in the Stockholm World Environment Conference of 1972 and then in the Rio Declaration of 1992. So the very principle 3 and 5 expresses the Earth's capacity to produce vital renewable resources be preserved and restored, and the proper use of non-renewable resources from the dangers of their future exhaustion. The Rio Declaration adopted Agenda 21 and also the Climate Change Convention and the Convention on Biological Diversity for environmental management to carry out the principles of sustainable development. And beforehand, the General Assembly of the United Nations Organization established the Brundtland Commission in 1983 and the Commission in its 1987 report and where it headed as our common future developed the ethics relating to environment and those recommendations of the Brundtland Commissions are the following. The first recommendation made by the Brundtland Commission under the heading Our Common Future is that every human being a part of community life is equal with all living creatures. And the second recommendation of the committee is that human beings have fundamental and equal rights to access to the resources. And the third one is so every life form need respect independently of its worth to people. And the fourth one is that everyone should take responsibility for the impacts on nature. And the fifth one, everyone should share fairly the benefits and costs of resources used. And also, there is the need to interlink the protection and of human rights and to that of the rights of nature. In regards to that, the Social and Economic Council of the United Nations Organization in the year 1993 established the World Commission on Sustainable Development to review the progress made under Agenda 21 and to make strategies for their proper implementation. And subsequently, the World Summit on Sustainable Development was held at the Johannesburg in South Africa in 2002, and the summit under the agenda poverty eradication and human development envisages that the problem confronting global issues like energy consumption, water and sanitation could be tackled at home by domestic legislation. The summit worked out on international framework for sustainable development, which includes the following principles laid down by the Johannesburg Summit on Sustainable Development, and which includes strengthening commitments to sustainable development, integration of economic, social, and environmental dimensions of sustainable development in a balanced manner, and also strengthening the implementation of those principles laid down in Agenda 21, and also promoting the rule of law and strengthening governmental institutions, and also enhancing participation and involvement of civil society in the implementation of those principles of Agenda 21, and so also strengthening international cooperation for implementation of Agenda 21. And in response to the above principles of Agenda 21, the Indian Supreme Court, in number of cases, urged the application of the principles of sustainable development, and Agenda 21. For instance, in the important leading case, Velour Citizens Welfare Forum versus Union of India in 1996, and also in the Indian Council for Legal Action versus Union of India in 1997, the Supreme Court applied those principles of sustainable development as laid down under Agenda 21. And in regards to that, the Broadland Commission's recommendation on sustainable development, the very report of Broadland Commission and some other international documents spelled out certain principles for effective working and efforts towards achievement of sustainable development. And among those principles, the major ones are intergenerational equity, the precautionary principles, the polluter pay principle, and the principle of no fault liability, and also the doctrine of public trust. So, these are the principles which are laid down as under the report submitted by the Portland Commission, and also the developments made in 1992 Rio Declaration in regards to Agenda 21, and also the summit development in Johannesburg of South Africa in 2002. And among those principles, the first important principle is regarding intergenerational equity. And as already we have discussed before 1 month ago in our channel about these principles, and again we want to repeat the very principle intergenerational equity and how it came into, as we found the very Stockholm Declaration of 1972 made indirect reference to the principle of intergenerational equity under principles 1 and 2 of the conference. So also principle 11 of the Rio Declaration of 1992 spelled this principle. Intergenerational equity means the right of each generation of human beings to benefit from the cultural and natural inheritance of the past generation, as well as the obligation to preserve such heritage for future generations. It, in its broad sense, refers to man's fundamental right to freedom, equality, and adequate conditions of livelihood in an environmental quality that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for the present and future generations. So the natural resources like air, water, land, flora, and fauna must be safeguarded for the benefit of the present and future generations through careful planning and management. And in this regard, we would like to discuss a leading case of 1999 decided by the Supreme Court, where in that particular leading case, Andhra Pradesh Pollution Control Board versus M.B. Naidu, the Supreme Court upheld this principle while delivering their judgment. Again, this principle of intergenerational equity was declared by the Supreme Court in 2004 case of MC Mehta versus Union of India. And now we'll discuss the very second principle of sustainable development, and that is the precautionary principle, which means principle of establishing a duty to take such measures that anticipate, prevent, and attack the causes of environmental degradation. The implementation of these duties that the development must assume from the fact of developmental activity that harm to environment and may occur, and that they should take that necessary action to prevent that harm. The principle of the Stockholm Declaration 1972 and the principle 6 of Stockholm Declaration of 1972 and the principle 15 of the Rio Declaration of 1992 speak about the precautionary principle. Thus, precautionary principle underlines to adopt environmental constraint in order to achieve sustainable development. So, in the leading case, Vellore Citizens Welfare Forum versus Union of India in 1996, the Supreme Court accepted the precautionary principle and observed that the state government and the statutory authorities must anticipate, prevent, and attack the causes of environmental degradation, and the onus of the proof is on the actor or the developer or the industrialist to show that his action is environmental friendly. The precautionary principle was directly and in detail was applied again by the Supreme Court in the Taj trapezium case in 1997 on the petition filed by N.C. Mehta. The apex court observed that the preservation of a prestigious monument like the Taj in view of precautionary principle, the environmental measures must anticipate, prevent, and attack the cause of environmental degradation. This principle was again applied by our apex court in Andhra Pradesh Pollution Control Board versus M.B. Naidu in 1999. And another important principle of sustainable development is the polluter pay principle. It raises two questions. One is, who is a polluter and what should the polluter pay for? But the real answer lies that the polluter should be at the expenses of carrying out the measures which resulted in the damage. For example, the harm caused to the environment not only extends to compensate the victims of pollution but also the cost to restore the damaged environment. The principle was applied in concrete shape by the Supreme Court in the case of Indian Council for Legal Action versus Union of India in 1997. This case was about the problems of people living in the vicinity of chemical industrial plants producing sulfuric acid. As a result of this, people continue to suffer due to pollution and lose the loss to the property, irreparable damage to the ecology and precious natural resources. So industries were compelled to their perform their responsibility and also their statutory duties and take appropriate remedial action. The polluter pay principle was also reiterated again in the famous oleum gas leak case of Delhi, also known as Sri Ram Fertilizers case. Among these number of cases, one single most important case was the Bhopal gas leak disaster case of 1989, where the Supreme Court not only applied polluter pay principle to the Union Carbide of India Limited, but also evolved the principles of absolute liability of state under which the state also bear the responsibility of sharing compensation equally with the polluter. And now we'll go to the next important principle involving sustainable development, and that is the principle of absolute liability extended in revolving the principle of no fault liability. Two most important cases, one is the Bhopal gas leak case and the other one is the Sri Ram food and fertilizers case, also the LG polymer case of Visakhapatnam or Andhra Pradesh. So in all these cases, Supreme Court expressed that it was no doubt the Union Carbide Corporation, this Ram Food and Fertilizers, and also the LG polymers were responsible for the loss and damage caused to the people and the property due to the leakage of ethyl isocyanate or the oleum gas. So also the central government was equally responsible to share their responsibilities. The court further observed that industry, particularly hazardous industry, are essential part of development where naturally people are involved. So even in the absence of any accident, an industrial enterprise without any fault shall have certain liabilities towards the society. In response to, in response to the decisions of the Supreme Court, the central government enacted the Public Liability Insurance Act of 1991 and also the National Environment Tribunal Act of 1995 and also the National Green Tribunal Act of 2010. So, now we'll discuss another most important principle involving sustainable development, and that is the doctrine of public trust. The very doctrine of public trust is derived from the Roman maxim, and we found its very origin in the form of res nullius and res communis, which means that natural resources owned by no one but by everyone in common. Under English common law, the crown owns all resources but could not grant these properties to private owners as to navigation and fishing, as these are held in trust for the benefit of the public. So, this notion means that the public has a great right over lands with natural areas. Accordingly, the government, as a trustee to these natural resources, is bound and under an obligation to see that there is no deviation from this, and such properties are not used for other purposes except for use by the general public. So, in that context, would like to discuss the decision of American Supreme Court in the leading case, Illinois Central Railroad Company versus the people of the state of Illinois. So, where the very American Supreme Court in this particular important leading case held that the doctrine of public trust was in existence since the Roman times. So, its validity is equally held and applicable even to the present time. So, also, in the important monolithic case, the California Supreme Court expressed and clearly shows judicial concern in protecting all ecologically important lands, for example, fresh water, wetlands, forest is among the purposes of public trust. This principle was also applied by the Indian Supreme Court or apex court in the important leading case MC Mehta versus Kamal Nath in 1997. As on the fact of the case, the Himachal Pradesh government granted lease of forest lands to span motel, which utilized it for commercial purposes by diverting natural flow of water up the river and some construction activities. The apex court held that as it is ecological importance with scenic beauty, so private ownership and use for commercial purposes is violation of the very doctrine of public trust. So, in this particular lecture, we have dealt to the most important aspects, and at the present scenario, it is the most demanding issue among the people all over the world regarding that very sustainable development. So, the very question and idea of sustainable development was first indirectly we found in Principle 6 of the Stockholm Conference of 1972. And again, that very idea was raised in the Rio de Janeiro Declaration of 1992 in Brazil on Earth Summit, and the very Agenda 21, which was declared in the Rio Declaration, that also heavily laid emphasis on sustainable development. And before that, the United Nations Organization in 1983 established the Brundtland Commission under the ex-German Chancellor Brundtland, and who submitted its reports in 1987 with some recommendations to the United Nations General Assembly. And subsequently in 2002, the Sustainable Development Conference on Environment was held at Johannesburg in South Africa in 2002, and in that connection also how the very principles of sustainable development were applied by the apex court or the Indian Supreme Court, that we have discussed two important leading cases. One is Vellore Citizens Welfare Forum versus Union of India in 1996, and the second one, Indian Council for Envo Legal Action versus Union of India in 1997. And after that, those important principles of sustainable development, such as intergenerational equity, precautionary principle, polluter pay principle, no fault liability, and finally doctrine of public trust. And while discussing very doctrine of public trust and how it was, the very idea was borrowed from the Roman maxim, and also how the American Supreme Court laid emphasis on the very doctrine of public trust in that important leading case, Illinois Central Railroad Company versus the peoples of the state of Illinois, and also the very famous important leading case of California, that was the monologue case, and which was also decided by the California Supreme Court, where it also laid emphasis on the doctrine of public trust. And finally, in Indian context, we have discussed the application of the principle of a doctrine of public trust in the important leading case, that is MC Mehta versus Kamal Nath in 1997, on the very fact and issue of the case relating to allotment of lease of natural forest land to private entrepreneur to build a span motel, and how the very doctrine of public trust was held by the apex court of India, that also we have discussed. So in this particular lecture we have discussed the most important issue all about the world in the present scenario, as climate change, global warming, greenhouse effect, biodiversity, and so also finally sustainable development. So we have completed our journey on this very particular issue, which we started at climate change, global warming, greenhouse effect, biodiversity, and finally we conclude on sustainable development.